All right, so that's how things are playing out now. Still with me, trial attorney Jamie White. Jamie, let's first go to that suggestion there by the attorney that she wanted to know the qualified panel for jurors and then when the line or the delineating line is for the picking of alternate jurors, something that oftentimes we don't see in voir dire. I want to get your thoughts on that.
I think those questions are really legitimate, Michael. Anytime that you're in the process of picking a jury, jury process starts from the moment you assemble in the room that morning throughout the time that you finish deliberating. And oftentimes, in cases that I've had, jurors maintain contact even after the trial. So there's a relationship building that occurs. And I think that these questions are appropriate. In a case of this magnitude, with the amount of media exposure and all of the other implications, it's completely understandable that the court has to make some special accommodations. However, I think the concerns of counsel are appropriate in that, what is this going to look like? How separated are these people going to be? We've seen this through COVID over the last, 18, 24 months where judges were experimenting with unique jury selection processes and even the organization of the juries themselves. And time will tell, and science will dictate to some degree whether or not those procedures work. But I certainly believe that the questions by counsel are appropriate, trying to figure out exactly what is this going to look like and what is the game plan going forward.
All right, now let's talk a little bit about strategy, a little inside baseball. When you go into the actual voir dire, we've been showing the attorneys as they ask questions. Again, reminding our viewers we cannot show the jurors, so that's why we keep the cameras fixated on the attorneys. And we hear them asking questions, Jamie, and you can tell from some of the questions what they're trying to accomplish. But there's a lot more going on there. There are questions, they're really setting up their case in many ways. They're creating relationships with potential jurors. Tell me a little bit about how that process goes for an attorney and what is he trying to accomplish beyond picking a juror or qualifying a juror?
That's a great question. So really, voir dire is probably one of the most important pieces of any trial because it gives you an opportunity to talk hypothetically about the case to some degree, and it gives you an opportunity to expose the jurors to some of your potential legal theories. When I would try a case, oftentimes I would find the person I knew that I was going to strike, but they would be somebody that I would ask a lot of questions to, not worried about having to offend them, knowing I'm already going to disqualify them, and allowing some of the other potential jurors to hear responses to those questions. When somebody comes clean, so to speak, that they can't be fair, they're going to be biased, they have a friend that's a police officer, they have a friend that was killed by a police officer, whatever side of the political spectrum they fall in a case like this, it's important for the attorneys, whichever side, to take advantage of that person and put questions out in front of them so that other potential jurors can hear maybe fantastical responses and things that otherwise can be brought up in closing arguments. It was very common for us to actually reference jurors who had been dismissed in our closing argument, bringing jurors back to the idea that you heard us ask a question whether or not John Doe could be fair. They said no, and this is why we asked that question, because we need you to be fair. It's a dance. It's complicated, it's unpredictable, and I think we're going to see a less than certain process during the next couple of weeks just because they only have so many strikes. And, once you're set with a jury, you're set. But it's a very important process and probably the most important piece outside of closing arguments.